Attorney Askew.
Good morning.
Good morning. Are you waiting for your client?
Yes, she told me she's in the waiting room. Is she not in the waiting room?
She is. I just want to bring her in.
Okay.
Attorney Alex, good morning.
Good morning, Your Honor. My client tells me he's in the waiting room on Zoom, ma'am.
Okay, I just brought him in as well. So we can do Kennedy and Childs. Attorney Grand, good morning.
Good morning, Your Honor. And just so you know, I'm going to be supervising the Attorney General Law Clerk Carmen Rankin, who's going to be handling today's hearing.
Okay, good morning, Ms. Rankin.
Your Honor.
Which case is this again? I always forget because that's not on the document, your name.
This is for Courtney Kennedy.
Hold on, I'm trying to turn the audio on. I'm sorry.
Okay, Courtney Kennedy is here. Let's call that first. Andre. Okay, thank you. Okay, if your case is not being called, I need you to go on mute. Okay, we're handling Courtney Kennedy.
Yes.
2356713, the people of the state of Michigan versus Courtney Kennedy. Ms. Kennedy is charged with one count of embezzlement, agent or trustee, $1,000 or more, but less than $20,000, set for a probable cause conference today. Appearances.
Good morning, Your Honor. Carmen Rankin requesting permission to practice under Michigan Court Rule 8.120 and under the supervision of Assistant Attorney General Steen Grand. I'm currently a 3L at Wayne State University in good standing.
Okay, I will allow it. Good morning and welcome.
Thank you.
Good morning, Lauren Askew, P79304 on behalf of Ms. Courtney Kennedy, who is here in the virtual courtroom.
And Ms. Kennedy, can you state your full name, please?
Yes, Courtney Nicole Kennedy.
Okay. So let's see. Today was an adjourned probable cause conference, is that correct?
Yes, that's correct.
Okay.
At this time, Your Honor, we do have we're working on an agreement, myself and the Attorney General. So at this time, we were going to ask if we could waive the exam and go to circuit court at this time.
Any objection from the people?
No objection, Your Honor.
Okay, Ms. Kennedy,
Yes.
I'm going to ask you some questions. If you can't hear me or if you don't understand me, let me know, okay?
Yes, ma'am.
Is it your wish to waive your preliminary exam today?
Yes.
You understand that you have a statutory right to a preliminary exam?
Yes.
That if you were to demand that exam, the people would have to show in the probable cause standard, which is a lower standard of criminal standard, that one charge I read off was committed in the city of Detroit and that you probably committed that crime. You understand that?
Yes.
Then by waiving your exam today, that means that people do not have to prove anything as a probable cause standard. Understood?
Yes.
Also understand that you are not waiving your right to trial.
Yes.
Knowing that information, do you still wish to waive your exam?
Yes.
Did anyone force you or threaten you to waive your exam?
No, ma'am.
Did anyone promise you anything?
No, ma'am.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Frank Murphy Hall of Justice, Third Circuit Court, for an arraignment on the information date of June 21st at 9:00 a.m.
Okay,
Anything from
I'm
either
sorry.
party?
Thank you, Your Honor. Have a lovely afternoon.
Thank you.
Thank you. You're all set, Ms. Kennedy.
Okay, thank you.
Everyone have a good day.
You too.
Thanks.
Delano Childs?
Ready?
Yes, sir. Yes, ma'am. I'm sorry.
This is case 2357099, the people of the state of Michigan versus Delano Childs. Mr. Childs is charged with count 1, weapons carrying concealed, count 2, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 3, police officer assaulting, resisting, and obstructing. Count 4 and count 5, weapons throwing firearms set for a probable cause. Conference today appearances.
Edward Zawaki, P5482A, appearing on behalf of the people.
Good morning, Joseph Alex P. 42284, appearing on behalf of Mr. Childs. Mr. Childs, introduce yourself to the court.
How you doing? I'm Delano Childs. Anthony Childs, Delano Anthony Childs.
Okay, Attorney Alex, do you have discovery?
I have discovery, Your Honor, digital and paper. My client wishes to waive his preliminary exam and proceed to Third Circuit Court.
Okay, any objection from the people?
No, Your Honor.
Okay, Mr. Childs, I don't know if you were listening to the last individual, Ms. Kennedy, but I'm gonna ask you the same question. If you can't hear me or if you don't understand me, let me know, okay?
Yes, ma'am.
Did you wish to waive your preliminary exam today?
Yes, ma'am.
You understand that you have a statutory right to a preliminary exam?
Yes, ma'am.
That if you were to demand that exam, you would have to show the probable cause standard, which is a much lower standard in criminal law, but still a standard, that those charges I read off were committed in the city of Detroit and that you probably committed those crimes. Do you understand that?
Yes, ma'am.
And then by waiving your exam, that means that people do not have to prove anything at that standard. You understand that?
Yes.
You also understand that you are not giving up your right to trial.
Yes, ma'am.
Knowing that information, you still wish to waive your exam.
Yes.
Okay, did anyone force you or threaten you to waive your exam today?
No.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. Your arraignment on the information date will be June 21st at 9:00 a.m. Frank Murphy Hall of Justice. Anything else from either party?
No, Your Honor.
Yes, Your Honor, I'd like to address the fact that he's required to have a tether. He's had some difficulties with the tether. He's actually been placed on house arrest. Initially, he was told he was not, then he was told he really was. I'm asking that you remove the tether. He's 22, he lives with his mother and his siblings. He's trying to go back to his employment in Chesterfield. He has one prior contact with the criminal justice system. There's no evidence of his failure to appear in any other court hearings. Consequently, I'm asking for you to remove the tether requirement.
Anything else?
We object, Your Honor.
I didn't hear what you said.
Huh?
I didn't hear what you said.
Oh, I said we do object.
Okay. What I will do is I will lift the house arrest. I don't see the need for that at all. I will keep the tether on, however, and send the information over to the tether unit right now so that he can seek employment.
Thank you very much, Your Honor.
You're welcome. Also, Mr. Childs and Attorney Alex, do I have both of your permission to sign the waiver form since we are both virtual?
Yes, you do, Your Honor.
Okay, Mr. Childs?
Yes, ma'am.
Okay, anything else?
That's for the people, Your Honor.
Okay, you have a good day.
Thank you. I'll call you tonight, Mr. Childs.
Okay, thank you.
Okay. Deanna Bailey,
Yes. Good morning, Judge. I'm here on Miss Bailey. Also here on Mr. Gladden.
Mr. Raddick, okay, thank you. I had to check into, attorney files, I overlooked.
Excuse me, Judge. It looks like,
Thank you,
Bailey is
Judge.
Sorry, what?
Bailey.
Oh,
Okay.
okay. So Bailey is also connected to Harris Urban. Attorney Cooper, are you ready to handle your client's case? Or are you waiting for your client?
Well, I've not been able to have any contact with him, Judge. I don't have discovery. I don't have a number, an address. I sent a letter to an address that I found online, but I got no response.
Okay, so I'm gonna call the case. All right, this is case 2357104, the people of state of Michigan versus Deanna Marshavia Shayer Bailey, defendant number 1, Jazzy Morris, defendant number 2, and Karis Alante Urban, defendant number 3. All defendants are charged with count 1, police officer assaulting, resisting, and obstructing, except for a probable cause count for state appearances.
Evan Zawaki, P5482A, appearing on behalf of P.
Good morning, Your Honor. Alicia Martin, P69003, on behalf of defendant number 1, Miss Bailey.
Renee Cooper for Mr. Irvin.
Ms. Bailey, can you put your name on the record, please?
Deanna Marshavia Sharon Bailey.
Thank you. And just to make sure, is there a Paris Urban in the meeting presently?
Yes. Yes.
Can you say your name, please?
Paris Turner.
Paris Turner,
Yes.
is your name, has your name ever been Urban?
Not legally, no.
Okay. Okay, well, Attorney Cooper, things have changed.
I see that. Well, your middle name is Alente, right?
Yes.
Okay. Yes, things have changed, Judge. I don't know if Miss Martin has had a chance to speak with Miss Bailey and if they've made any decisions, but I don't have discovery yet.
We need, Mr. Cooper's P number.
Mr. Attorney Cooper, can you provide your P number to the prosecutor? They're gonna send over the service.
Of course, I'm sorry, 30566.
Thank you, sir.
Your Honor, I did receive a discovery link from the people and I am ready to proceed to exam.
Okay. The exam date I have on here is the 14th of June.
That would be good for me, Judge. And
Okay.
all I need is Miss Turner's phone number.
Okay.
I mean, yeah, Turner, yeah.
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 Don't give me now, we're on YouTube. Before you log off, I'm gonna get the number, we're gonna get the number from you so you can talk to your attorney, okay?
I couldn't hear you.
Don't log off without providing your phone number to you, okay?
Okay.
So June 14th, does 9 or 9:30 work?
No,
Either one is fine.
I need later in the morning, Judge.
11,
Yes.
Attorney Cooper?
That's fine for me.
Okay. Ms. Turner?
Yes.
And Ms. Bailey, your exam has been set for June 14th at 11 a.m. 36th District Court in person. You understand?
Yes.
Okay. I think that's everything, and discovery should be sent over Attorney Cooper to you shortly. Anything else from either party?
No, Your Honor.
No, Your Honor.
No, thank you.
Okay, and Attorney Cooper, do you want to go into a breakout room with your client?
Very much so. Thank you.
Okay.
Hello.
Kevin Martin?
Yes, Your Honor.
Ready, Your Honor.
Okay. Give me 1 second here. File.
Excuse me, Your Honor. I'm free to go.
Yes,
yes.
Ms. Bailey, you can log off.
Okay.
You're all set. This is case 2357000, the people of the state of Michigan versus Kevin Martin. Mr. Martin is charged with count 1, controlled substance delivery, manufacture of cocaine, heroin, or another narcotic less than 50 grams. Count 2, controlled substance delivery, manufacture of cocaine, heroin, or another narcotic less than 50 grams. Set for a probable cause, count for state appearance.
Evans Walker, CR438, appeared together, people, Your Honor.
Good morning, Your Honor. For the record, Coleman Potts, P78607, on behalf of Mr. Martin, who appears via Zoom. Mr. Martin, please state your name for the record, sir.
Kevin Martin.
Your Honor, today's date time set for an adjourned PCC. We adjourned this matter to review the digital discovery that we did not have previously. At the review of that discovery, it's clear that there's some things left out. We have an exam date currently of June 16th, but at the review of that discovery, not only will I need the additional body cam from the other stop they mentioned on camera, I also need to make sure that I've subpoenaed all the officers to make sure they're at the preliminary examination. So I went and demanded exam. Your Honor, I just don't believe I'm going to have everything I need by the 16th.
Okay, have you communicated with the people what it is exactly that you're looking for?
No, Your Honor. I just discovered this stuff this week, but I will because I didn't know exactly who the courtroom prosecutor was, but if I can get their email, I'll send them an email with the additional information that I need.
Okay, I'll send it to you right now. So how much time do you think you need?
Well, if I'm assuming an additional 2 weeks from today, because I need to get the subpoena out from the officers. I'm assuming the body cam shouldn't be that hard to get.
So June 21st?
May I check my calendar, Your Honor?
Sure.
June 21st will work, Your Honor.
Okay.
What time would that be on the 21st?
Give me 1 second. Do you know which one that old? 1:30.
1:30. I have a trial in Rochester. Actually, the trial's at 2:30, so I don't think they'll make that. But I have a 2:30 trial set for Rochester Hills.
Okay, you do 9 o'clock?
Yes.
Okay, so June 21st at 9 o'clock.
Thank you very much, Your Honor.
You're welcome.
All right, have a good one.
You too. Mr. Martin?
Yes, Your Honor.
So your exam has been set for an in-person exam. The date's been changed to June 21st at 9 o'clock a.m. Person at 36th District Court. You understand?
Yes, Your Honor.
Okay, you're all set. You can log off. Have a good day.
All right.
Thank you.
Excuse me, Judge.
Yes, good morning.
Good morning. My client is in the hallway,
Oh,
Mr.
okay.
King Brown.
All right, we'll bring him in.
Okay, thank you.
Attorney Forrest, good morning.
Good morning, Your Honor. Here on Monique Randolph is present.
Okay. This is the people of the state of Michigan versus Monique Randolph, 2357116. Ms. Randolph is charged with count 1, sold a dangerous weapon, felonious assault, count 2, weapons, stun, firearms, set for a probable cause conference today. Appearances.
Edwin Sawanky, P5482A, appearing on behalf of the people.
And good morning, Your Honor. Matthew Forrest, P73168, appearing on behalf of Monique Randolph, who's present via Zoom.
Ms. Randolph, can you say your full name, please?
Monique Yvette Randolph.
Thank you. Okay, Attorney Forrest, do you have discovery?
Judge, I do have most of the discovery. I did have a chance to begin review of the body cam that was sent to me. And so I received 3 different body cams from 3 police officers. And there were at least 6 officers that responded to this incident. And so I need the balance of that body cam footage. But other than that, I believe I do have complete discovery, and we would just ask for an exam date. And I do need to address bond.
Okay. This is the one regarding the body cam footage.
I'll have to check on the, oh, I see.
Okay. All right, look at the date and then we can discuss bond. So the date scheduled here is for June 14th. Can you do that day?
Judge, that is a bad date for me. I'm available the 15th around 11 if the court is.
Yep, 11 o'clock on June 15th works. Okay, and go right ahead with bond.
Judge, currently, as part of bond, Ms. Randolph is on a GPS tether with very restrictive hours of only being able to leave the home between 7:30 and 8:30 a.m. and 2:30 and 3:30 p.m. I'm not aware of any assaultive history of Ms. Randolph or any history of failing to appear in court. The complainant in this case is unknown to Ms. Randolph. She has no connection to the complainant or the complainant's family whatsoever. This incident alleged to have occurred at the Rouge Park. I believe after speaking with Mr. Kirker yesterday, the only concern regarding the tether was contact with the victim. And as I stated, Ms. Randolph has no idea where these people live, doesn't know them at all. So I don't believe that a tether is necessary in this matter, and I'd ask the court to remove it.
We object to the removal of the tether. We don't object to the hours.
Okay, Attorney Forrest, what I will do is lift the house arrest and any curfew. That way you can tether on.
Thank you, Your Honor. So no hours restrictions?
No
Thank you.
contact with witness in the event that she does know who that person is. But I don't think there's an issue with that on this case. So Ms. Randolph, you are free to leave the house and do what you need to do. Just no contact with the complaining witness via social media, third party, okay?
Okay.
Anything else?
No, thank you, Your Honor.
You're welcome. You have a good day.
Thank you.
You're welcome. Okay.
You know, I'm sorry, what was the date on that, the time for the preliminary exam? We can get you. Thank you.
Mr. Brown, come up to that first row right here. Yep.
Judge, can we call Mr. Radin, my other client?
Yes, because this next one is a 3-bagger. Okay, Mr. Brown, you can have a seat. We're actually gonna call this case. This is the people of the state of Michigan versus Stephen Michael Radin, 2356544. Mr. in charge with 1 count of weapons carried concealed, set for a probable cause conference today. Appearances,
Edward Zawaki, P54828, appearing on behalf of the people.
Alicia Martin, Your Honor, P69003, on behalf of Mr. Stephen Radden, who is present on Zoom.
Mr. Raddick, can you state your name, please?
Stephen Radden.
Thank you. Good morning.
Good morning.
Martin, do you have discovery?
I do.
Okay, looking for an exam date?
Yes, ma'am.
Okay, do you want to do the same day for your other exam?
Yes, Your Honor.
Okay, what day was that? Because I forgot already.
It was June 14th at 11. So, we can do it right after, that'd be great.
Okay, June 14th at 11:30.
Okay, thank you, Your Honor.
You're welcome. Mr. Raddick,
Yes.
your exam has been set for an in-person preliminary examination for June 14th at 11:30. Do you understand?
Yes.
Okay, anything else from Mr. Party?
No, Your Honor.
All right, you have a good day. Attorney Barrett, there's a 3 defendant case. I'm making sure everybody's here first.
Oh, okay.
And Judge, good morning. I'm here on Mr. Hanash, same case.
Oh, okay. That solves my issue. And then Andre Simpson. Is there a representation, attorney here for Andre Simpson?
Good morning, Judge. Yes, Nicole Casca, I'm here.
Oh, good morning. Okay, let's call it.
Yeah, okay.
This is case 2357092. People of state of Michigan versus Jimmy Hanash, defendant number 1, King Edward Brown, defendant number 2, and Andre Lamont Simpson Jr., defendant number 3. Defendant number 1 is charged with count 1, organized retail crime. Defendant number 1 is charged with count 2, weapons, felony, firearm. Defendant number 2 is charged with count 3, controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Defendant number 2 is charged with count 4 and 5, count 4, weapons, felony, firearm, count 5, weapons carrying concealed. Defendant 3 is charged with count 6, stolen property, receiving and concealing a motor vehicle. Defendant 3 is charged with count 7, organized retail crime. Defendant 3 is also charged with count 8, stolen property, receiving and concealing $1,000 or more, but less than $20,000, with an habitual offender fourth offense notice for defendant number 3. Set for a probable cause conference today. Appearances.
Edward Zawaki, P54828, appearing on behalf of the people.
And Judge, good morning to you and your staff, as well as Sister Counsel Vincent Haysha, P76506. On behalf of Mr. Hanash, whose presence I'd ask the court to waive, I've been in contact and he is on bond.
Good morning, Melita Baird on behalf of King Brown.
Mr. Brown, can you say stand up, petition name for the record, please?
King Edward Brown Jr.
And Mr. Brown is in the courtroom physically.
And good morning, Your Honor. May it please this most honorable court, Nicole Casca, P55470, on behalf of Mr. Andre Simpson. Mr. Simpson and I are appearing by Zoom video. Mr. Simpson, please state your full name for the record.
You're on mute, Mr. Simpson. Unmute your device.
Good morning to the court. My name is Andre Lamont Simpson Jr.
Good morning. Okay, does everyone have discovery?
Judge, I do have paper discovery and I do have video discovery. I haven't had an opportunity to review the video discovery as of this morning.
Judge, I had discovery, but we wanted to waive our preliminary exam. I don't know what the other attorneys want to do.
Okay.
Okay. Well, Judge, as to Mr. Hanash, I received a link that only had paper discovery. I don't have the videos, and I'm going to need those videos.
Okay, as far as Mr. Hanash.
Yeah, the videos are in that link. the way they get sent, you'll have to contact an IT person and see if they can open it for you. Because if I resend it, it's gonna be the same thing.
Okay, well, I mean, I downloaded it yesterday, and the only thing that was in there was the investigator's report. I'm positive on that. I'll double check. I think it's unusual that one defendant would have it and one wouldn't. So maybe it's on me, but I'll double check today.
Yeah, it's a separate link.
Okay, all right. I'll double check.
Yeah, and if you can't find that link, then let us know. We'll resend it then.
Sounds good.
Judge, I think what might make sense is maybe another PCC, just so that we all have a chance to get on the same page and actually have a chance to talk with one another too, as far as councils.
I think that's fair as well, Your Honor.
I don't,
She's waiving. Mr. Brown is waiving today, correct?
yes, Judge.
Okay. So Attorney Casca, you have discovery, Attorney Haysha, discovery was sent. So, I would like to set the exam date. I'll set another PCC, but I do want to get the exam date on the docket.
Sounds good.
Okay, Judge.
Let's see here. The date set is for June 14th. Does that day work?
I'm gonna be
Judge,
in trial, Judge. I'm gonna be in a jury trial on Frank Murphy, Hall of Justice.
Okay, what will be your next available day?
Judge, I think we can do the 15th. My trial starts on the 13th, so it should only be 2 days at maximum. So as soon as I have a jury deliberating, I can go and have somebody babysit and go across the street or get on Zoom, Judge.
And the 15th is fine that's fine for a PCC.
I was actually stating that for the exam.
You want the 15th for an exam, Your Honor?
Yeah.
Judge, I'm going to be in Ann Arbor, so that I could remote in for a PCC, but I can't do an exam that morning. I have an exam in Ann Arbor that morning, and the way that they do that, I have no idea when I'll be called or, what time I would be back in the city. So I don't think the 15th will work.
Okay. Next day available.
What about the 16th, which is Friday?
The 16th, I have an exam in Ypsilanti, and I'm in Warren in the morning. So no. Could we go to the week of the 19th? I have considerable availability then. 22nd would be fine. 23rd would be fine.
22nd works for me. 22nd works for me, please.
Okay, 22nd at 9 o'clock.
For exam?
Yes.
Okay, I just want to make sure I'm putting the right thing in. Yes, Judge.
Yep. And do you want another PCC in between there?
That might be smart, just because things after my client and I talked, we may have a different strategy, but I want to have an opportunity to have that discussion with, being able to go through all the discovery, please.
Okay, just tell me what day. It doesn't matter what day for the PCC.
Thanks.
Okay, Judge, I'm looking at that week before, like either the 15th or the 16th.
Yeah, 15th is fine. 15th works for me if we want to do a PCC.
You all let me know what day you all want to do for the PCC.
15th?
Okay, 8:30.
Yep, Judge.
Your Honor.
Okay. And then we have Mr. Brown. Anything else for Attorney Casca and Haysha?
No, Judge, thank you very much.
No, Your Honor.
All right, you're welcome. You have a good day.
Thank you. You too, Judge.
You as well.
Am I able?
Mr. Simpson and Mr. Hanash. Well, Mr. Hanash is not here. So Mr. Simpson, you're free to go. Set for June 22nd at 9:05 a.m. in person at 36 District Court. You understand that? Mr. Simpson? Okay. Okay, now back to Mr. Brown. Mr. Brown? Okay, Attorney Barrett, are you ready for me to go ahead and question your client regarding his waiver?
Yes, Judge.
Okay. Mr. Brown, is it your wish to waive your preliminary exam today?
Yes.
Do you understand that you have a statutory right to a preliminary exam?
Yes.
And that if you were to demand that exam, the people will have to show at the probable cause standard, which is a lower standard in criminal law, but still a standard, that all the charges associated to you in that charging sheet and information were committed in the city of Detroit, and that you probably committed those crimes. You understand that?
Yes.
And that by waiving your exam today, that means that people do not have to present any evidence at the probable cause standard regarding those charges. Do you understand? You also understand that you are not waiving your right to trial?
Yes.
Knowing that information, you still wish to waive your exam?
Yes.
Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
Okay. Any objection from the people?
No objection, Your Honor.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. Mr. Brown, you will be bound over to Third Circuit Court, Framework for All Justice, for your arraignment on the information on June 21st at 9:05 a.m. Okay? And Attorney Barrett, do I have your permission to sign the waiver form since you are virtual?
Yes.
Okay. And Mr. Brown, I'm gonna have you sign your waiver form, and then you are all set, okay? Anything else from either party?
No, Your Honor.
Okay.
No.
Have a good-
You too.
Thank you. Mr. Brown, this one. We need you to sign here, and then you can leave. You have your date? You remember your
June
date?
21st.
June 21st, 9:00, Framework for All Justice. That's correct. No, you gotta sign this form first, Mr. Brown. Good morning.
Good morning. Oh.
Here. Yeah, here. Attorney Robinson, good morning.
Good morning, Your Honor.
How you doing today?
I'm pretty good. How are you?
Pretty good. Get through it.
Good.
What do we have?
Avant Nance or Nance, and I don't have a telephone number for Avant Nance.
I see he's logged on. Finally here.
Great.
Avant Nance.
Yes, ma'am.
Okay, before we get off, when we get done with this case, make sure that you talk to your lawyer and find a phone number for her, okay?
I'm sorry for that. You said phone number?
Once we're done with your case today, do not log off until you talk to your lawyer, okay?
Yes, ma'am.
Okay. It's the people of the state of Michigan versus Avant Nance, 2357080. Mr. Nance is charged with 1 count of stolen property, receiving and concealing a motor vehicle set for a probable cause conference. Day appearances.
Edward Milwaukee, P5488, appearing on behalf of the people.
And good afternoon, Sarah Robinson. Not good afternoon. I've been up a long time. Good morning. Sarah Robinson, P63181 for Mr. Avant Nance.
Mr. Nance, can you state your full name for the record, please?
Avant Deshaun Nance.
Okay, Attorney Robinson, do you have discovery?
I have discovery. Request
Okay.
exam.
Okay, I have the date of 6/14, June 14th. Does that work for you?
Let me check, Judge. I can make it work, Judge.
Okay, 9:30, 10:30?
10:30, please.
Okay, Mr. Nance,
Yes, Your Honor.
your exam has been set for June 14th at 10:30 a.m. in person at 36th District Court. You understand?
Yes, ma'am.
Okay, anything else from either party?
No, Your Honor.
All right, you have a good day. Mr. Nance. He was supposed to stay on until. Oh, yeah. Hey, good morning. Attorney Schwab, good morning.
Good morning, Judge.
How are you?
I'm good, thank you.
You ready?
I am.
Okay. Attorney Robinson, I do have, the person with the phone number 687-2471, can you state your name, please? The person who just logged in on Zoom, can you state your name? If you do not announce who you are, I'm going to log you off from Zoom. You have to go on YouTube if you'd like to view the proceedings. The person with the phone number 687-2471, can you state your name, please?
Nicole Nance.
Ms. Nance, you do not have a case
Yes.
today, do you?
I didn't hear you.
You have a case today, or was that your son?
Oh, no, my son.
Okay, since he logged off, do you have his phone number so his lawyer can contact him?
I'm sorry, I didn't hear you.
Do you have your son's phone number? The lawyer's been trying to contact him, but she doesn't have a good phone number.
Wait a minute, hold on a second. 1-678-876-4518. Yeah, I told you.
876.
Wait a minute, wait a minute, let me go back to it. 1-678-876-4518.
Okay. All right. So his date has been set for an exam for June 14th in person at 10:30 at 36th District Court.
Okay, will that be on Zoom or we have to come in?
In person at 36th District Court. He heard all of that. I'll just give you a courtesy, the courtesy information since you're here.
Okay then.
All right. You have a good day.
Okay. Yeah, you too. Thank you.
Okay. Attorney Nelson, good morning.
Good morning, Your Honor.
Yeah, Mr. Hobbs.
I do.
Mr. Hobbs didn't appear today.
Yes. I have not had any contact with Mr. Hobbs. I would ask for a brief adjournment so I can have my investigator try to make contact.
How about the 12th?
Yes. What time?
8:30.
30. All right. I'll see you then. Thank you, Your Honor.
Okay, Ms. Wilson. Okay, we are on the record, this case of State of Michigan versus Shanice Hilton, case 2356474. Ms. Hilton is charged with one count of police officer assaulting, resisting, and obstructing, set for exam today at 9 o'clock.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. James Schwab, 30720, on behalf of Ms. Hilton.
Ms. Hilton, do you take her full name for the record?
Yes. Middle name as well?
Yes.
Shanice Rochelle Hilton.
Good morning.
Good morning.
Okay, today's date set for exam, I have a waiver form for me. Is it correct, Attorney Schlott, that your client be waiving her exam?
Yes, Your Honor, I've explained to her statutory right to a preliminary exam. She's gonna waive.
Okay. Any objections from people?
No objection, Your Honor.
And Ms. Pilgrim? Yes. Did anyone force you or threaten you to waive your exam today? No. Did anyone promise you anything? No. And you do understand your statutory right to have an exam today? Yes. Okay. I find waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Third Circuit Court, Frankfurt Hall of Justice. Your arraignment information date will be 2 weeks from today, June 21st at 9:00 a.m. Line is continued. Anything else?
No, Your Honor, thank you.
Thank you all. Have a good day.
Yeah.
Oh, man. Let's get you'll stand in front of the yellow circle.
Morning.
Right,
How are you?
I'm okay. How about yourself?
Try to get through this docket. How are you?
Of course.
All right, Mr. Hill. Good. How are you? All right, we're on the record. This is the people of the state of Michigan versus Juwan Hill, case 2356434. Mr. Hill is charged with 1 count of controlled substance delivery, manufacturing marijuana, and count 2 weapons on firearms set for exam today. Appearances.
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. Attorney Gregory Sheena, P74815 on behalf of the defendant who's present. I'm standing to my right, Your Honor. We did execute a waiver of my client's right to an exam. He does understand his rights. He did sign the waiver, and you should have it in front of you, Your Honor.
I do. Mr. Hill, can you state your full name for the record?
Juwan today here.
Okay. Any objection from the people?
No objection, Your Honor.
Okay, Mr. Hill, you understand your statutory right to a preliminary examination?
Yes, I do.
And that if you were to demand that exam today, the people would have to show a probable cause standard, which is a much lower standard, but still a standard in criminal law, that those 2 charges that I read off were committed in the city of Detroit and that you probably committed those crimes. Do you understand that?
Yes.
And that by waiving your exam today, people do not have to present any evidence to prove anything at that standard. Do you understand?
Yes.
Do you also understand that you are not giving up your right to trial?
Yes.
And knowing that information, do you still wish to waive your exam?
Yes.
Did anyone force you or threaten you to waive your exam?
No.
Did anyone promise you anything?
No.
I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over to Frank Murphy Hall of Justice, Third Circuit Court, for the arraignment on the information date of June 21st at 9:00 a.m. The bond is continued. Anything else from either party?
Nothing from the people.
Your Honor, can we get the next arraignment day? I'm sorry.
I wish I can't change that.
No, okay.
No,
Okay.
it's hard to-
Who was the judge on that?
I don't know.
Oh, you don't even know.
No.
Okay.
I just sent it over.
Thank you.
I don't know if it's in person or Zoom either. I have no information.
It's okay. We'll figure it out. Thank
Okay.
you. Have a great
Good
day.
seeing you. Have a good week.
You too.
What?
But, okay, the officer's here.
Attorney Robinson, your client is back. Do you want to speak to him in the breakout room? Mr. Nance?
Yes, ma'am.
Yes.
I just talked to your mother. She gave us your phone number, but I'm gonna put you in the breakout room so you can speak to Attorney Robinson, okay?
Yes, ma'am.
Okay, this is the people of the state of Michigan versus Thomas Andrew Watson, case 2356516. Mr. Watson is charged with one count of weapons carrying concealed, set for an exam today. Appearances.
Edmund Sawaki, P5428.
Veronica Walbrad, P856665 with NTS Detroit, on behalf of Mr. Thomas Watson, who's present in the courtroom. Please state your name for the record.
Thomas Andrew Watson.
Good morning.
Okay, is everyone ready to proceed?
Yes, Your Honor.
Apologies, sorry, I had to mute this very quickly.
We're ready, Attorney Walbrad.
Yes, yes, Your Honor. Oh, apologies, we are ready to proceed, and I'm sorry for the feedback.
Okay. Any preliminary matters?
None from the people, Your Honor. Our OIC is the president and he's not testifying.
Okay, the objection to the OIC in the courtroom?
No, Your Honor.
Okay, if there's anyone on YouTube or Zoom who may be a witness on this case, now's your time to log off. As well as the courtroom, if there's anyone who may testify or the witness to the case, now's your time to leave the courtroom, except for the officer in charge who will not be testifying today. With that, you can call your first witness.
Thank you, Your Honor. People call Officer Bailey. Officer Black. Apologize again for this pronouncement. Easy for the name was to walk here. Better.
You'll get it. He keeps coming in here.
Your name.
Yeah.
Whenever you're ready, Mr. Sawaki.
Thank you, Your Honor. Officer, could you state your name and occupation for the record, please?
My name is Bailey Rumschlag. I'm a police officer in the city of Detroit,
How long have you been with that agency?
about 6 years.
And were you on duty April 18th, 2023?
Yes.
And were you in the area of 7 Mile and I believe it's Garner?
Yep.
Okay. Is that in the city of Detroit and County of Wayne?
Yes.
What were you doing
Just on patrol.
there? And what did you observe?
Observed, we were northbound on 100 from 7 Mile. Observed Mr. Watson walking southbound in the street. In his right pocket, he had a heavily weighted, very clear print of a handgun in his pocket.
So what did you do at that point?
I pulled up next to him, still in my scout car. Simply asked him if he had a CPL. He said no.
At that point, what occurred next?
I got out of my scout car and took hold of his hands. Observed.
Were you with other officers at that time?
Yes.
And they were,
Officer Turner and Officer Hill.
and what occurred next?
I got out of my scout car, took hold of Mr. Watson's hands, observed Officer Turner recover a black Taurus G2 handgun from Mr. Watson's right pocket.
Do you know if that weapon was loaded?
Yes, it was.
And what happened with the weapon and ammunition?
They placed on evidence at the 11th precinct.
And looking for this time.
When you were on patrol, there was no call or other alert that drew your attention to Mr. Watson?
Correct.
Okay, you saw him walking down the street.
Yes, ma'am.
Okay. And you saw him from the distance of a vehicle. He would be on the sidewalk or edge of the road and you were in the middle, right?
Yes.
And he was wearing dark pants, correct?
Correct.
And you saw a weight in his pocket, right?
Heavily weighted, yes.
Okay. Those were sweatpants, right?
Correct.
Okay. And from the scout car, you asked him if he had a CPL.
Yes.
Okay. At which point you and your two partners who were on patrol immediately exited the vehicle. Is that fair to say? So I'm going to say no, you got out right away.
Correct.
Within a matter of 5 seconds or less.
Yes.
Okay. And you immediately took control of Mr. Watson's hands.
My best recollection, yes.
Okay.
That's what I did.
Okay. Without asking him any further questions.
Yes.
Okay. And without confirming whether he had a weapon on him.
I knew he had a gun in his pocket.
Okay. When you say took control of his hands, you mean you applied handcuffs?
I literally grabbed his wrist first, and then my partner recovered the gun, and then I placed him.
Okay. I am.
Let's have my sequence mixed up.
Okay. I'm going to show you. Sorry. This is his you were wearing a body camera that day?
Yes, ma'am.
Would you be able to recognize the body camera you were wearing?
Yes.
Okay, very short.
Okay.
Does that look like the body camera that you were wearing on this day?
Yes, ma'am.
Okay. I asked the court if I could share my screen. Should be able to. Okay. So this is starting from 12 seconds. That's pretty much you exited the vehicle, correct?
Yes.
Okay, and from there, you have control of Mr. Watson's hands, is that correct?
Yes.
Okay. And are applying cuffs while your partner recovers.
Correct. It was all
Simultaneous.
Yeah.
Okay.
Are you going to admit this?
Yes, Your Honor. Defense Exhibit A, there's no objection.
No objection.
You'll be admitted as defense exhibit A.
And when you you say that you knew there was a gun in his pocket, you're referring to the weight that you saw in his pocket as you were driving up the street?
There's multiple observations looking at like a gun in someone's pocket. There's a pendulum swing because of the heavy weight. There's a clear pistol print, so there's little support of the pants pocket. I've made over 300 CCW arrests in my career. Very experienced in this sort of thing.
Okay.
I knew it was.
And no one asked Mr. Watson verbally if he had a weapon on him after his arrest? Yes.
No, not that I
Not
recall.
to your recollection, okay. And I know I already asked you, but when the three, when you and your partners exited the vehicle, the car was in front of Mr. Watson, right?
Yeah, sort of.
And there was one person on each side, correct?
Correct.
Okay, no further questions.
Can you redirect?
Okay.
Officer. You have your camera on today?
Yes.
Okay. Was it located in about the same place? If you can recall.
If I recall, it should, yeah.
Okay. And the camera just shoots in one direction, right?
Correct.
Okay, so your eyes and head turn in basically 180 degrees, give or take.
Yes.
Okay. I have nothing further, Your Honor.
Thank you, Judge.
No further witnesses, Your Honor.
Nothing from defense.
Your Honor, people move to have the defendant bound over on count one weapons carrying concealed. Reserve on.
Your Honor, defense would object to any bind over in this case. The police initiated a stop of Mr. Watson from the vehicle. They did initially make verbal contact, but they immediately exited the vehicle and positioned themselves around him in such a way that a reasonable person would not interpret themselves to leave the vehicle on one side. One officer on each side and one officer behind him immediately securing his hands. It was only after his hands were secured that there was any confirmation that there was actually a weapon. And officers exited the car and initiated this stop, which I believe to be without reasonable suspicion based on viewing a heavy object in his pants from the distance of a car driving down the street. The officer did testify to some elements that would help him identify a weapon in a person's pants, but I don't see a differentiation between what he has described and any heavy object in a sweatpant, which is a stretchy fabric, that I don't believe constitutes reasonable suspicion to initiate stop without some verbal or visual confirmation of a weapon beyond the bulge or a vein in the pants pocket. And I would ask that the court suppress that stop and the resulting search and dismiss this case.
Your Honor, this is a probable cause hearing. People have met the person. The officer testified that not only did he bulge, but the bulge was L-shaped, and there were other factors giving him a reasonable suspicion that there was a weapon. He did, even before they got out of the car, they confirmed that the defendant did not have a CDL license, and they knew that he had a weapon. They arrested him. They searched and found the weapon. This is a case of for the trier of fact. It's a question of fact, and we ask for binding.
I do think this would be a question of fact for the trier of fact. This is a very, very quick sequence. Did see part of the video as well as her testimony from Officer Rumschlag. And he was certain his experience, that that was a handgun in his pocket. That would be a question for the prior fact to determine whether or not it was, or that it was sufficient enough for reasonable suspicion. Like I stated that he knew it was a gun, he defended hands were heavy weighted, and he saw the L-shaped print of a handgun. The question was asked whether or not he had CPL, he had CPL after Rumschlag. Officer Rumschlag pulled up next to the defendant and they said no. And very swiftly, along with one of Rumschlag's partners, Officer Rumschlag held his hand, and I believe it's Officer Turner, I'm not sure, one of the officers recovered the handgun from the pocket based on evidence, and the defendant was simultaneously placed in handcuffs. I think it would be a question of fact to try to determine whether or not that sequence of events was appropriate. This standard, I do believe, the people have made first proof. So we bound over, sir, to Third Circuit Court, Craig Murphy Hall of Justice, for the regular information date of June 21st at 9:05 a.m. Anything else from you, party?
No, Your Honor.
No, Your Honor, thank you.
Madam Clerk, just on, I believe Attorney Haddad is here for Attorney Phelps. Okay. Well, I don't believe the defendant is here yet. Okay. Mr. Wiley doesn't, okay.
Nope, why not here?
So it's set for 9:30.
Are you saying for Phelps, Ms. Carson? Officer Carson?
Yes, ma'am. Yeah. Bring all your things with.
No, I don't need this, I'm just checking to see if I got the digital discount.
The Jackson.
You need a minute for roll call, that's fine.
No, Your Honor, I was just looking to see, maybe I'm better.
Davion?
That's Davian.
Davian.
Yes, ma'am.
Okay, we're on the record. This is the people of the state of Michigan versus Davian Wells. 2356500. Mr. Wells is charged with one count of assault with a dangerous weapon, felonious assault, set for an exam today at 10 o'clock. Guarantees.
Alexander Kirker on behalf of the people, P86282.
Your Honor, John Gold for P 30758 on behalf of Mr. Wells. Mr. Wells, is your name on it?
That's Davian Lamar Wells.
Good morning.
Good morning.
Is that ready to move forward?
The people are your honor,
That's right, Your Honor.
Any preliminary matters?
none from the people.
You know, I think we Mr. Kirby. Reviewing my files, we did receive paper discovery, but I would ask digital discovery, publishers, body cam, et cetera, be provided. Not for the purpose of exam, but for the procedure sheet.
I resend it.
Okay,
Thank you.
all right. If there's anyone on Zoom or YouTube who may be a witness on this case or testify on this case, now's your time to log off. Same in the courtroom. If there's anyone in the courtroom who may be a witness on this case that may testify, now's your time to exit the courtroom. Mr. Kirk, you call your first witness.
Your honor, this time the people call Denzel Laird.
Step up to the young lady right there in the class.
Right here.
Yes, stand right there, sir.
Denzel Laird. DENZIELLAIRD.
Turn to the judge, raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Pull this door open right here, have a seat. Make sure you speak up with that microphone. You can hold it in your lap.
Yeah,
Ready.
Alright, could you please restate your name for the record?
Denzel Laird.
And I want to take you back to the date of April 13th, 2023. Do you remember that day?
Yes.
Were you at or near the location of 19373 Goldburn Ave?
Yes.
In the city of Detroit, county of Wayne?
Yes.
And did something happen that brings you into court today?
Yes.
And what was that?
I was sick in a basement crowbar.
And I want to back up. What brought you to that location?
I would just be over there all the time. That's my godbrother's place.
Godbrother?
And my car is there, so I fix on my car there too.
Your car was there?
Yeah, my car there, and I fix on it over there.
And what led up to you getting hit in the face?
Davian asked me, he had work, and he worked 2 jobs that I know of. And he asked me, he had someone, a friend at work that needed her brakes done on her vehicle. And he said he had to go to work, so I told him I'll do the job for him. And he was like, well, we can split the money after it's done or whatever. And I said, cool. So the girl came to get her brakes did, but I started on the back.
Excuse me, if we could get to some dates when this possibly could.
Sure.
Did this occur on the same date that I had stated, April 13th?
No, this was like 2 days before, maybe, yeah, about 2 days before.
Alright, okay. And did you complete the work on this car?
No, I couldn't. Well, he completed his end in the front, majority of it. I started on the back, but she needed new calipers, so I couldn't finish the job. So we notified her she needed new calipers. We told her to come back the next day, which would have been the 12th. When she came back on the 12th, they didn't notify me she came at all. But
And when you're saying Davian, is there somebody present in the courtroom today that you're referring to?
yes,
Could you please point out that individual and identify an article of clothing they're wearing?
black,
I'm sorry, we'll stipulate for the purposes of exam here, right?
Okay.
And, please continue.
oh yeah, so she came back on the 12th. And when she came back, he didn't notify me that she came back at all. I just happened to wake up in the house and came out and he was doing the job.
And when you say he, who are you referring to?
David. So when I came out, I still assisted him with finishing the job. And he asked me for help while he was doing it. He took her car back. Once he took her car back, he never came right back. So when I came, I went in the backyard and started working on my car. And when he came back to get
Your
money,
Honor, again, Your Honor, I'm not sure which date we're talking about.
this would have been the 12th.
So,
Which is not the date of the allegations, is that correct? I'm going to object to this. The question started out, how did this come about? Now we've gone into soliloquy about
It's a narrative.
narrative. Yeah,
Narrow it down to.
we're trying to get to.
Okay, so,
Is it layered?
yeah.
Make sure, just wait for the prosecutor or the lawyer, depending on who's up there, just to ask you a question.
Okay, that's fine.
so what happened on the day of the 13th?
Okay, so on the day of the 13th, I text Davian's phone, and I told him, I said, because he tried to give me some of the money. He only tried to give me $20 out of it. And I wanted the full payment of mine.
And what was the full payment?
We supposed to split it 120 and a half, which would have been he 60 and I get 60. He made an agreement with the girl.
Again, Your Honor, we're back into any agreement that he had with the girl is irrelevant at this point in time. We're back into there.
And let's stick to the date of the 13th and what happened on there.
Okay.
Mr. Director, can you, like, OIC name on the record for appearance of record? OIC is deputy clerk. Yeah, okay, Detective Devin Brown. Any objection?
No, Your Honor.
Okay.
So after you only received $20, what did you do?
I texted his phone, he had left. I texted his phone, I said, the girl need to pay us the rest of the money.
Again, Your Honor, this all calls for hearsay. He's talking about the girl. The girl is not relevant at this point. My understanding, this testimony was that on the date of the 13th, Mr. Wells gave him some money and then left. That's what I've got out of this testimony. So.
You have a response?
Acknowledge, Your Honor.
I didn't hear any hearsay.
What the girl was telling me, clearly.
I believe he was saying that he was texting the defendants.
That's all you were saying, to text the defendant that the girl needs to get paid. The girl needs to pay the rest of the money to Mr. Laird. Not what the woman said to him. But, no, that's even no.
And after you texted the defendant, what happened?
He texted me back basically saying, I could tell he was kind of upset about that. I wanted the rest of my payments. So he came, he left work, he sped down the street super fast. I was sitting on the porch. He got out of his car. He had a computer in the house. And
so the defendant made the location?
Yes, he left work just to come here.
And what happened when the defendant arrived at the location?
He got there, he came, he started grabbed his computer out the house. When he went in there, I heard him talking to my brother.
Objection, Your Honor. At this point in time, we're back into a narrative.
And what happened when he went into the house?
He grabbed his computer, he took it next door to his house, which he lives next door.
And at any point, did you engage with the defendants? Did you speak with the defendants?
No, not right then and there, no.
At what point did you come into contact with the defendants?
Once he made about 3 or 4 trips back and forth, after he had already got what he needed from out of the house and was going back and forth with everybody.
And what happens when you made contact with the defendants?
He was saying like, okay, we gonna see, because I had told him like, bro, they was arguing with him about telling him like he wrong, he needs to give me the money.
Excuse me.
And who was arguing? Who was arguing with the defendants?
My brother and my godbrother.
And at some point, did you enter into this argument, or?
Yeah, yes.
And what happens between you and the defendants?
I didn't even actually argue with him. I told him, I said, my point of it was more to them telling him, just let it go, because he's not understanding the point of what y'all trying to explain to him for him to pay me. And he was getting irate like, oh, well, we gonna see, and making trips back and forth.
We're going into narratives. We don't even know what the name of the brother is or the guy. And it's all hearsay about they were arguing. And I'm objecting to this nature unless we can get some verification as to who these arguments initially started with.
At this point, the witness is talking about the defendant saying, we'll see to him. This is not about the brother or not brother.
I haven't heard any hearsay this last response, but if you can clarify, if he mentions his godbrother or names, what they were doing.
But at this point, I understand between him and the
That's correct.
And so after the defendant said, we'll see, what happened?
He went next door again into his home, came back like 2 more times. Now, me, I know he has a firearm.
Objection, Your Honor. There's no allegation of any type of firearm in this particular matter. He knows.
Well, I don't respond.
This could go to fear of defendants or perceived threats.
I don't even know what the next part of the testimony is, so
Now neither do I.
okay, so let's stick to, the question was.
What happened next?
What happened next? Okay, so what happened next?
He came back again. Then we met. We were face to face having an argument.
Is this you and the defendants?
Yes. And then he ended up grabbing my wrist, like both of my wrists, like, you know how somebody grabs their hands and like hold them down.
So the defendant that did this?
Yes.
Okay.
When he grabbed both of my wrists, I like, you know, like how you swindle out, like let me go. And then
You were trying to, so he was grabbing with both of his hands?
Yes.
And that motion that you just made, was that you trying to
Get
wriggle away?
yes, to get free.
And what happened? Were you able to get free?
Yes, when I got, well, me getting free, when I was wiggling out, he pushed off, like shoved me off.
Was this the defendant that pushed you?
Yes.
And what happened after the defendant pushed you?
Once he pushed me, he came back and I pushed him back. Then when he came back again, that's when I defended myself and hit him.
And when you say you hit him, where did you hit him?
I just threw a punch in the face.
And what happens after this, after you punched the defendant?
He fell back, he came up with the crowbar and instantly started hitting.
And could you describe the crowbar?
It's about this long.
Do you have an estimate of how many feet that is?
About long as my leg. It's about like, what was I gonna say?
2 to 3 feet? That feet?
Yeah.
And what happened when the defendant had the crowbar?
Like, what did he do with it?
Yes.
He hit me with it.
And where did he hit you with it?
Right here, this one, it cut my face open. And then.
And is that, I see you're pointing to the right side of your face?
Yes.
And how many times did the defendant hit you with the crowbar?
I got 3 different sets of stitches, so I know for sure I got hit 3 times. But I was told by the witnesses that I was hit.
All right, well, first of all, he's now going, I was told by, that's hearsay.
Yes, that's
Second
getting
of
ready to be
all,
hearsay.
either he knows how many times he got hit, or he doesn't know how many times.
Acknowledge it. How many times do you know that you got hit?
4 for sure.
And where were you hit with the grill bar?
Right side of my face, jawline. Left side of my face, cheek, closer to the ear. My right in the back of my right arm, and then my back on the left side.
And did you receive any injuries from this incident?
Lacerations.
And did you seek medical attention for those injuries?
Yes.
Did you receive any stitches?
Yes.
Recall how many stitches you received?
I received 3 on the right side of my face, 4 on the left side, or there's 4 or 5 on the left side, and 5 of them are 4 in the arm.
And were you in pain in this incident?
Yes, my whole face was sticking out over here on the right side.
Are you still suffering from this incident?
I mean, it's hard to look at it. I mean, but it is what it is.
I have nothing further, Your Honor.
Cross.
So, Mr. Blair, is it?
Yes.
Yes, sir. So my name is John Goldfield, and I'm going to ask you a couple of questions. If you don't understand the question, please say so, and I'll rephrase it.
Okay.
And if it calls for a yes or no answer, just say yes or
Okay.
no. Oh, Mr. Blair, it's my understanding that you have known Mr. Wells for quite a period of time. Is that correct?
Correct.
And you grew up together and you live next door to each other?
We don't live next door to each other.
Okay. Now, you indicated that on the day or a couple of days before this incident, you and Mr. Wells were working on an individual automobile?
Yes.
And who was that individual?
I don't know her.
And you were going to split the job and you had an agreement that he was going to get some of the money and you were going to get some. Is that correct?
That's correct.
Now, it appears from your testimony that on a day or two before the incident, there was some discussion about the young lady coming up with more money that was agreed upon. Is that correct?
Can you repeat that?
It appears that a few days before the incident, that there was some disagreement or discussion between you and Mr. Wells regarding the amount of money that this young lady has paid. Is that correct?
No, that wasn't a few days.
Okay, when was that?
That was about the day before.
Okay, so the day before. All right, so that would have been on the 12th, correct?
Yeah.
And this young lady was supposed to pay more money for you to do something on the calipers, is that correct? Calipers?
Well, her paying more wasn't discussed until we ran into the problem.
Okay, so let me get this straight. Mr. Wells was working on the front of the vehicle.
Yes, sir.
And you were working on the rear of the vehicle.
Correct.
And Mr. Wells had done his part, is that correct?
He didn't get the finish work either, but he got more done than me.
Okay, he got more done than you did.
Yeah.
And when Mr. Wells, let me ask you a question. On the 12th, when you were working on the calipers, you found out that you didn't have enough money to get the job done. Did you continue to work on it?
Us not working on the calipers wasn't about not having enough money. It was her calipers were seized, so
okay.
That was on her.
Okay.
That wasn't our fault.
Okay, no, I understand that, but, so in other words, This was additional to what you were supposed to have done on the hours.
Yeah, we were supposed to do brakes and rotors.
Okay, and the brakes and rotors were, brakes and rotors on the rear weren't done, correct? Because of the seized calipers.
Correct, yeah.
Now, on the 13th, you indicated that there came a point in time when you had a conversation with Mr. Wilkes, is that?
Correct.
And was that conversation in person?
Text.
Text?
Yeah, I actually sent them a text message first.
My question was that conversation in person?
No.
There come a point in time when there became some text between you and Mr. Wells.
That was first.
Okay, well, there came a point in time, correct?
Yeah.
All right. And after this texting, was there any mention about you owe me money or I owe you money or what's going on in this case?
No, I don't know.
All right. So when Mr. Laird, when Mr. Wells comes to your location, you indicated he went inside of his house. Does he live next door to the home, residence where this altercation?
Yes.
And who lives at the house where the altercation?
My godbrother.
Pardon?
My godbrother.
Your godbrother. And what's your godbrother's name?
Jalen Tab.
Okay.
Jalen Gabriel Tab.
Okay. And was he one of the individuals who was arguing with Mr. Wells prior inside the house?
Correct.
Okay. And you also indicated that there was another individual.
Yes.
And who?
That's my brother.
Okay.
My
What's
brother.
his name?
Cody Laird.
Now, he also was arguing.
Yes.
And was this after you had spoken to these individuals regarding any problems with Mr. Wells?
No, because I kind of feel like you should be more specific about what you mean by.
Well, you indicated, I will. You indicated that he came over and he came to your residence.
Right.
You had no contact with him when he initially returned to your residence, is that
correct?
And he went into his house?
No, he came straight to the place we were at.
Okay, so were you inside or outside?
I was sitting on the front porch.
Okay, so he walked right by you?
Walked right past me.
And went inside to talk to
Yes.
your godbrother and your brother, is that right? Didn't you have any conversations with him at that point in time regarding the money that was owed?
I can't do it on the porch.
Right.
I can't have a conversation with a person if I'm on the porch in the house.
My question is, you walked right by you, correct?
Yeah.
And your differences regarding the money was between you and him.
Yeah.
Right? So why didn't you have a conversation with him at that time?
Because he was already upset when he got there.
Right? He was already upset when he got there.
The text message proved he was upset.
Okay, and we don't have a text message, right?
Well, I do.
Yeah, okay. The, was he upset with you?
By the text, I was the only person texting him, so it had to be upset with me.
Well, he was upset with you, and you were upset with him because you weren't getting your money. Why didn't you address the issue at that time?
Because I knew him for so long that I already know how to address him.
Okay. So in other words, you allowed your brother and stepbrother to escalate this argument, correct?
No.
Okay. Now, you testified also that there comes a point in time where he is going back and forth into his house, and getting items, etc. You also indicated that there comes a point in time where you two get into an argument.
Yes, yes,
Correct. And isn't it true that it was you who started this argument and demanding your payment? Is that?
No, I don't call it starting an argument. I call it do what's right. You know,
Okay.
make sure it's not the
So you got into an argument with him, which you initiated, correct?
I don't call it initiating.
Okay. And when you and your, and Mr. Wells are arguing, where is, Mr. Laird, your brother, as well as your godmother?
At what point of the argument?
When you and Mr. Wells started arguing about the money.
Well, the argument started in the house.
What, did you go into the house as part of this argument?
I was in the house, I left the porch and was in the house telling them, well, if you heard me, I was telling them that he's not understanding it, so just let her know.
Now everybody's outside again, right?
Yeah, now everybody's
Now
outside.
you're.
Some people are gone, to be exact.
Okay. Now, when you were outside. Arguing with Mr. Wells.
Right.
Where was your brother, Coley, and where was your stepbrother?
My brother Cody, he was standing outside, and my stepbrother, he was gone. There was another individual there at that point of the argument.
Who was that?
JaVale, what's that? I want to say McGowan.
Okay.
He's 13.
Pardon?
He's 13.
Okay. And you then testified that an argument ensues, he grabs you by the wrists.
Yeah.
Correct?
Mhm.
Right? He doesn't hit you, he doesn't push you, he just grabs you by the wrist.
Yeah.
Right? And isn't it true that at that point in time, you pull away and then you punch him? Isn't that correct?
Yeah.
Right? So he grabs you by the wrist, and then you punch him. You pull away, and it's over, right? He's not hitting you, he's not swinging at you. You turn around and you punch him. All right. And isn't it also true that at that point in time, he falls back and Mr. Laird Senior totally gets involved in the argument? Correct?
No.
He doesn't get involved physically in the argument. Okay? Isn't it true that this other individual, JaVale, also becomes involved and is starting to attack Mr. Wells? Isn't that true?
Based on your story, no.
Based on my story, no. All right.
So this the order is kind of wrong.
Isn't it true that it was only after these other two put themselves into the melee?
The other two got involved once they seen my face and get me.
You said you were going to answer my questions, and they didn't understand. Okay? Isn't it true that it was only after these two became involved in the fight and argument again that Mr. Wells grabbed this crowbar and self-defense?
Not correct.
Okay. And isn't it true, sir, that Mr. Laird, as well as yourself, were reaching into Mr. Wells' pockets, trying to grab any money he might have had?
I don't recall that.
You don't recall that? Okay. Well, you wanted your money, right?
It wasn't that deep. It was more of a.
It wasn't that deep.
What you saying is not, it's not that deep to me, like how you phrasing it to me, it's not that deep. It's kind of like a trick question that you get.
Well, did you, you wanted your money, right?
Yeah.
Okay.
Of course, I did a job.
Okay. Sure, you did your job. And he did part of the job, right?
But he got his.
Question was, you wanted the money that he had in his pocket, right?
No.
You wanted.
I wanted my money.
You wanted your money. So you thought he was holding out on you, correct?
You mean by holding out?
You did your work, you got paid, you didn't get paid. Why haven't I got paid for my work?
Oh, yeah, that's what you mean by holding out.
That's what I mean. And you thought that, right?
You read it.
You thought that he was holding out and not paying you what you.
I just felt like he didn't want to give it to me. Because some other stuff, yeah.
And because of that, you were mad.
I wasn't mad.
Was that you were grabbing for his money and your brother and stepbrother or Mr. Zlev became involved in this matter?
Can I ask you a question? Because I mean, I'm kind of confused by what you're saying.
Okay.
Because you keep saying grabbing, I grabbed the spot, when his pocket out.
Did you do that?
No.
Did your brother?
No.
And where did he obtain this crowbar?
From in front of my car that I was working on.
Okay. And where was that in relation to two of you after you punched him? Well, you punched him, you told him, and he fell to the ground. Is that correct?
Yeah, well, he didn't fall on the ground. He, like, you know, stumbled back, like.
All right. And then you continued.
No, I was instantly cut that fast.
Now, are you aware of any video cameras at the home or the apartment, at either his home or at the home, security cameras?
Yes, they actually just put another one up to so, they actually just put another one up to watch us.
Okay. And you say they asked you that?
No, I said they actually just put another video camera up to monitor us.
Did they actually?
Yeah, they just put another one up.
When was that?
It's been up since they instantly got it put up like after the incident. About a week later.
Okay. Was the one up there before that?
There was one up there before that.
Okay. And do you have access to that?
I don't have access. That's not my home. I don't have access.
Okay. Is it on the home where you reside?
It is that they got to put it up. So.
Did you ever get your money?
No, I got $20 and his dad gave my brother to send me.
So you got how much total?
I'm sorry,
did you-
Attorney Goswell, I didn't hear your response. What did you say?
I said he only gave me the $20 and his dad. Well,
What did you say? Just repeat
I
what you
said
said.
he gave me $20 and his dad gave my brother some money.
Dad.
Okay. When did he give you the $20?
That was like after he gave the girl the car, like gave her car.
Was that before or after the incident?
That was before the incident.
So he gives her the car back. He gives you $20.
Right.
And then the next day is when all this other happened.
No, that's what I was trying to tell you. You just didn't let me. He gave me $20. But before he gave me the $20, he didn't even want to give me that.
Question is, sir, he gave you $20 before
the incident. Yes.
13.
Yes, the incident that he gave me $20 daylight. The incident happened nighttime.
And you said his father gave your brother?
Yes, in bribery.
I'm going to object to that, Sean. Why would he give it to him? Your family received an additional $60. Is that correct?
I just got what I was paid. I don't know what was given.
You
Like,
just
I don't
said.
know what was given. All I know is dad told me. His dad told me I gave your brother some money, and this other people saying no, he didn't. And it's like he said, she said. That don't really concern me. It's just what happened.
Why would somebody give you
Bribery. I've been dealing with it since before I came here. Bribery.
That's not curious. Any other questions, Ron?
Can you redirect?
Just briefly to clarify one point from Cross. Did others become involved in this altercation between you and the defendants?
Yes.
And at what point did they become involved?
When they see me bleeding everywhere and knocked out.
Was this after you were hit with the crowbar?
This is after. Yeah.
I had nothing further, Your Honor.
And those others, was that your brother and your friend Jabel?
Yes.
When the police arrived, was your brother there? The police came to this location.
You said, yeah, they came, yeah.
Was your brother there at the time?
Yeah, I think he was in the street. All right.
Any other witnesses?
None from the people. Not this time around.
Your Honor, at this time, the people move to bind over the defendant on count 1, assault with a dangerous weapon. As we've heard from the witness, there's some sort of agreement between him and the defendant to do some work on a woman's car and then split the money. Go through all the facts, but at some point, both of them do work on this car. However, an argument ensues over how much each was owed for it, how much was actually paid for doing the repairs. The arguments then escalated into a physical altercation after the defendant grabbed both of the complaining witness's wrists and pushed the complaining witness. The fight went back and forth, and then the defendant grabbed a 2 to 3 foot crowbar and he hit the complaining witness. The complaining witness said at least 4 times. The complaining witness stated that he received numerous lacerations, which resulted in 3 stitches to the right side of his face, 4 to 5 stitches to the left side of his face, and 5 stitches to his right arm. He believed that the burden of probable cause and moved to bind over the witness.
Question, fact, Your Honor.
Here's a question.
Standing.
People will have to show the probable cause standard first that the defendant either attempted to commit battery on Mr. Laird or did an act that would cause a reasonable person to fear or apprehend immediate battery. In this case, we have testimony from Mr. Laird that the defendant did hit Mr. Laird in the face as well as on parts of his body, with him having to receive about 12 stitches. 2, that the defendant intended to either injure Mr. Laird or to make Mr. Laird reasonably fear immediate battery. In this case, it was actual injury. 3rd, that at the time the defendant had the ability to commit a battery, appeared to have the ability, or thought he had the ability. In this case, he did have the ability, he did so. And 4th, that the defendant committed assault with a dangerous weapon. In this case, there was testimony of the crowbar. This is a big question of fact regarding several things that were mentioned from Mr. Laird. At this point, weapon is burden of proof. So I will have found over Mr. Wells, excuse me, to Frank Murphy Hall of Justice for your random of information, date of June 1st at 9:05 a.m. And Attorney Gold finally requested the discovery, visual discovery to be resent. I think the Kirker's video is the
Thank you.
Anything else you need to mark?
Your Honor, continue.
Your Honor, just briefly, the complaining witness prior to this did discuss with me the defendant's father offering to make payments for his not appearing in court and making various threats. I told the complaining witness that this continues to call the police. That's one thing we're aware of necessary.
In other words, I'm trying to, of course, that would be unacceptable. That's what he was alluding to, so the brother has to. I'm not sure.
Definitely unacceptable. Mr. Kirker, as you make sure you reinforce that contact police, so that would be a bribery charge that would have to be investigated and charged. Mr. Wells, as far as you like to contact Mr. Laird, you understand that?
Yes.
Okay. That means not through third parties, social media, letter, form, communication, whatsoever. Okay? So no contact is in order, box continued, and we put on the record that There have been some issues regarding bribery that prosecutor has told the complaining witness threat to contact the police if there's or anything else.
No.
Okay. You're on set, Mr. Will, if you can wait in the hallway.
Thank you.
Thank you.
Well.
Is there?
Okay, we're on the record. This is case 2356953, the people of the state of Michigan versus Charles Morris, also known as Charles Curry Morris. Charged with one count of controlled substance, possession, cocaine, heroin, or another narcotic, 50 to 449 grams set for an exam. Appearances.
Edwin Zawaki, P5482A, appearing on behalf of the people.
Good morning to this honorable court. Carla Marable, P number 62755, on behalf of Mr. Charles Moore. Please state your name for the record.
Charles Morris.
Okay, so we had a off the record discussion between Attorney and Mrs. Milwaukee. The defendant present regarding some additional charges that the people are looking to add. And Attorney Marable, you're requesting adjournment so that you can have time to prepare for those new charges. We have discussed the date of June 30th at 9:30 a.m. for the new exam date. Is that my understanding of what's going on today?
Yes,
Yes,
Your
Your
Honor.
Honor.
Correct understanding. Okay, so June 30th, 9:30.
Thank you, Your Honor.
Wait.
This is case 2356947, people of the state of Michigan versus Christopher Marlon Harris II. Was charged with count 1 police officer fleeing third degree vehicle code with the habitual offender report defense notice set for an exam today. Appearances.
Milwaukee, P5488, people.
Good morning, Your Honor. Kalilia, Kahlilia, Davis, P70729 for Mr. Harris, who is present and standing to my immediate left. Mr. Harris, will you state your name for the record?
Harris.
Good morning. Your Honor, today is the date and time set for preliminary examination. I've explained to Mr. Harris the nature and purposes of a preliminary exam, as well as his rights to hold such an exam, and he's elected to waive that right.
Is that correct, Mr. Harris?
Yes, yes.
You understand that if you waive your exam today, the people do not have to present any evidence today at the probable cause standard? Did anyone force you or threaten you to waive your exam today? I didn't hear you speak up.
No, ma'am.
Did anyone promise you anything?
No, ma'am.
Any objection from the people who waived?
No objection, Your Honor.
Okay, I find waiver to be freely, understandingly, and voluntarily given, Mr. Harris. If
Yes.
you are in custody, you'll be bound over to Third Circuit Court, Frankfurt Hall of Justice, 1 week from today, so it'll be June 14th at 9:05 p.m. Okay?
Thank you, Your Honor. Your Honor, we just wanted to put on the record again that Mr. Harris still has not received his mental health treatment. He would like to take his medication.
That was on May 30th, where the file was marked medical, and nothing has changed.
Speak up.
No, ma'am. Not even my medication, my regular, not just mental health, but no medication. I get a very sporadic and very minimum standard dosage of insulin, and that is absolutely it. That's only when they feel like.
You need insulin?
Yes, ma'am.
Are they giving, are you saying, Mr. Harris, that that that's the only medication they're giving you and that's not being given on a regular basis?
So, is there another case that he's investigating?
I don't know, Your Honor.
I got a violation of probation, which I'm actually,
Where is that at?
that's, I'm doing that right now. What, Deborah Thompson was the original judge of record, but she had a substitute stand in.
Okay, so is that at circuit court, sir?
Yeah, but I'm done. Yeah, I'm sentenced to it. On that matter.
Well, how long did you send it?
June 20th is when I get out.
Okay. Because you have a personal bond on this case, so I'm trying to figure out why you're still in custody. Attorney Davis, can you? Well, June 20th is right around the corner.
Right.
I don't know if it's urgent or not, but Judge Thomas.
Apparently there's an issue with that as well, but I will try to do what I can do. I'll find out where it's gonna go.
Because I don't know what I can't do anything. He will be released with my case.
I understand that. I like to put on the record when the jail is not doing what the jail ought to do, so that later on, my clients will have some proof that it should have been known that they should have received their treatment.
Okay, I will see everyone sign a waiver for anything else from either party.
Nothing from the people, Your Honor.
Mr. Harris, I hope that you get the treatment or medication that you need. I'm sure Attorney Davis will do the best she can to get that for you, okay?
Thank you.
Right, you're all set, Mr. Harris.
Thank you, Your Honor. Have a great afternoon.
Excuse me, Lieutenant Dabney, Dabney said to call before they bring them down.
Murphy.
Nobody called? Okay. Hey, Lieutenant Dan, this person is even, they ready to bring it down. Give it 2 minutes.
Everybody watching today?
This is the people of the state of Michigan versus Jerome Tooks, 2305-685-301. People of the state of Michigan versus Jerome Tooks, charged with one count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams, set for exam today. Appearance.
Alexander Kirker on behalf of the people, P 86282.
Neighborhood Defender Service by Jonathan Cohen, P 86151, appearing on behalf of Mr. Jerome Tukes, who was present earlier but has had to leave for childcare purposes. I'm requesting to waive his appearance this morning.
I will waive his appearance. Okay, I am going to adjourn this matter. An urgent situation with this child, and I would allow for him to log on Zoom. However, the officer or officers present today also have to leave at this time. Is that correct, Mr. Griffin?
That's correct, Your Honor.
Okay, so I'm going to adjourn this to June 14th at 10:30 a.m. In person. Anything else?
Not from the defense. Thank you very much, Your Honor.
Were the officers from the state officer?
The troopers, yeah, I was gonna go.
Okay.
We are on the record as the people of the state of Michigan versus Rainey. Case 2356993. Mr. Rainey is charged with one count of possession or sale of weapons, taser, with the habitual offender second offense notice set for an exam today. Appearances?
Alexander Kirker on behalf of the vehicle P 86282.
Good afternoon, Judge. We are there on behalf of Randy, Judge, for some reason, they're not responding. I don't have an explanation.
Okay. All right, anything for the people?
The people who decide the KPS be issued.
I will issue a KPS. It'll be $2,000 cash assured, and you can bring your client in or set a date for the arraignment. If you find it.
Okay, all right, thank you.
Thank you. Good afternoon.
Very good.
All right, next. Stand right.
Okay. Okay, this is the people of the state of Michigan versus Bernard Lewis Osborne, charged with count 1, stolen property, receiving and stealing a motor vehicle. Count 2, police officer fleeing 443, vehicle code set for exam. Pearson.
Alexander Kirker on behalf of the vehicle P 86282.
And good morning, Your Honor. Robin McCoy, P63057, on behalf of Mr. Bernard Osborne, who stands to my right.
Mr. Osborne, can you state your full name for the record, please?
Bernard Lewis Osborne.
Good morning or good afternoon. Okay, today's set for an exam. I have a waiver form before me. Is it correct, Attorney McCoy, that your client is waiving his exam today?
Yes, that's correct, Your Honor.
Objection from the people.
No objection, Your Honor.
Okay, Mr. Osborne, I'm going to ask you some questions. If you can't hear me or if you don't understand, let me know, okay? Is it sure which way your preliminary exam today? Do you understand that you have a statutory right to an exam?
Yes.
That if you were to demand an exam today, that people would have to show that the probable cause standard, which is a much lower standard in criminal law, still a standard, that those 2 charges that I read off were committed in the city of Detroit and that you probably committed those crimes. You understand that?
Yes, ma'am.
And then by waiving your exam today, that means that people do not have to present any evidence today. Understood? Knowing the information, you still wish to waive your exam? You also understand that you are not waiving your right to trial? And anyone force you or threaten you to waive your exam?
No, ma'am.
Did anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. You'll be bound over to Third Circuit Court, Frank Murphy Hall of Justice, for an arraignment on the information date of June 21st at 9:05 a.m. Frank Murphy Hall of Justice. Anything else to be heard?
Nothing for the vehicle.
Nothing from the defense, Your Honor.
Okay, I have everyone's signature, so we're all set on Mr. Osborne. Got a good one.
Mr. Osborne.
I gotta do it then coming up. We're doing yes, we're doing President, 220. Yeah. Okay, I'll send you. Okay, I need to come visit. Yeah, please do. All right, see y'all later.
Yep.
Your name, sir?
Okay.
Okay, we are on the record with the people of the state of Michigan versus Melvin King, case 2356877. Mr. King is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons, felony firearm. Count 3, weapons, ammunition, possession by felon. Count 4, weapons, and firearms. Count 5, weapons, firearms, discharge, enter the building. Count 6, weapons, felony firearms. Count 7. Actually, no, count 7. This is a visual offender 4th offense notice set for an exam. Appearances.
Alexander Kirker on behalf of the vehicle P 86282.
Good afternoon, Your Honor. Earl Washington, Neighborhood Defender Service, P31383, on behalf of Mr. Melvin King.
Mr. King, can you state your full name for the record, please? Okay. Is everyone ready to hold the exam?
Yes, Your Honor.
Yes, Your Honor.
Any preliminary matters?
Yes, Your Honor. This time the people would vote to admit pursuant to MCL 76611.11 B1B. Certified copy of the defendant's previous felony charge of assault against a great bodily harm.
And Attorney Washington, have you had an opportunity to review that?
Yeah, and I have no objection for exam purposes.
Okay, if we people to bid number one.
Can I approach him?
Yeah. Anything else?
Nothing further from the people.
Yeah.
Okay, Vice President.
This time the people call Officer Kyle Durant.
Oh, I. Make sure you speak up. Everybody, Mr. Trigger?
Good afternoon. Could you please restate your name for the record?
Officer Kyle Durant.
Officer, are you currently employed, and if so, in what capacity?
Yes, I'm employed by the city of Detroit as a police officer in the 8th precinct.
And how long have you been employed as a police officer?
Been on patrol for over 2 years.
And were you employed as a police officer on May 11th, 2023?
Yes, sir.
Did you in fact work on that date?
I did.
Were you by yourself or with a partner?
I was with a partner,
What is your partner's name?
Officer Carson Hopman.
And did your duties as a police officer take you to an area at or near Former Street?
Yes,
Is that in the city of Detroit, county of Wayne?
it is.
And who brought you to that area?
So it was originally a shot spotter run that we were dispatched for.
And what is ShotSpotter?
ShotSpotter is a technology that triangulates gunshots and then immediately gets dispatched as a police run.
And you said it was originally, did something change?
Yeah, so once we showed up, we spoke to the victim and it became apparent to us that a building had been struck that was occupied.
And after speaking with the victim, what did you do?
So at the time, we still thought the suspect was inside of the house. So we requested additional units to try to set up a perimeter around the house and waited for supervision to come get further direction as far as making contact with the suspect who was to be inside the house at the time.
And did the additional units arrive?
Yes.
And what happens when the additional units arrive?
So it was a unit from our sister precinct showed up, we directed them to show up one street to the east of us to have cover the back of the location. Once they were there, they saw an individual.
Objection as to what somebody else saw.
Was the defendant inside the house at the time?
No,
Was the defendant taken into custody at any point?
he was.
Was the defendant brought to the scene?
He was.
And could you, is there anybody present in the courtroom today that you came into contact with on the date?
Yes.
Could you point out that individual and identify what clothing they're wearing?
Individual in the first row wearing the greens.
Your Honor, let the record reflect the identification of the defendants. And at what point was the defendant brought to the house?
So immediately after he was detained by the unit from 6, we radioed them to bring him to the house where he is then transferred to our police vehicle.
And after the defendant withdraws to the house, what happens?
So we conducted a well-being check on the house.
What is a well-being check?
So since gunfire had been, shown that was in the area, we've seen shell casings on the edge of the house. We wanted to make sure that no one was inside the house that had been shot. I've heard yelling coming from in or around the house, prior to, the suspect being detained. And so we had, possibility there was someone injured inside the house.
I just ask for clarification, the term suspect and defendant. These are two different people.
Oh, so, Mr. King, the defendant, I apologize.
Okay.
We always refer to suspect in our reports. I'm just used to that.
Okay, I just want to make sure. It's the same. Thank you.
And what were the results of the well-being?
So no one was found injured inside the house. However, we spoke to the detectives who,
Objection as to, anything, hearsay.
I believe the officer was gonna say what he had said. Could you clarify who the we is?
Yes, and as long as it's what you said is fine, and it's not what you said, unless there's an exception to hearsay, then it would be purposes.
understood me.
Did you speak to the detective?
Yes. So spoke to Detective Mott, who created a search warrant, and then the house was subsequently, searched upon the approval of the search warrant.
So this house was searched after the approval of the search warrant?
Correct. So a well-being check was conducted after no one was found injured inside. Search warrant was then, created and was approved. The house was searched.
And pursuant to the search warrant, did you search the home?
I was part of the search, yes.
And did you make any recoveries?
I did.
And what were those?
So several spent shell casings were recovered. 2 live 9mm bullets were recovered, in addition to a shotgun with live shotgun ammunition was recovered from the house.
And where was the shotgun recovered?
The shotgun was in a bedroom downstairs.
And you stated there were also 5 rounds for that shotgun?
Correct.
You also stated that there were 9mm?
Correct. So there was, I believe, 2 spent shell casings outside the house, and then there was 1 live casing on the front porch of the house, another live casing on the sofa in the living room. So 2 spent shell casings, so the bullets have been fired. Those were recovered on the north side of the house. And then there was a live round, so ammunition that has not been fired. There was 1 round on the front porch of the residence. And there was another 9mm round that had not been fired that was on the sofa inside of the living room.
Did you make any other recoveries inside the home?
Yes, we recovered looked like medical discharge paperwork for Mr. King. It was located up in the attic of the house, had his name on it. So essentially paperwork with his name on it inside the residence.
And did you speak with the defendants?
I did, sir. So he admitted that it was his
Well,
house.
Judge, I would object to any, statement without a foundation being laid as to this.
Or a question,
Sorry.
or a question. There was no question, you just said you speak to the answer is yes. But I'm sorry.
Yeah, well, I would object to anything elicited from, defendant, unless there's a foundation laid as to, his constitutional rights.
Mr. Becker, can you flesh out?
Was the defendant in custody at this point?
He was.
Was the defendant issued his Miranda warnings?
He had not been issued those yet.
And is this when you spoke to the defendant?
Correct, yes. So I did not interrogate him, but there was conversation that went back.
Well, I would object to anything, elicited while he's in custody without that, foundation.
Mr. Becker?
Well, there's two parts of the custodial interrogation. One is whether the defendant feels as though he's free to leave. As the officers testified, he was detained at this point. The other is how closely the interrogation resembles the in-station interrogation that was present in Miranda v. Arizona. And this is different. This is still at the defendant's residence or at a home out in which the defendant is outside the home. And so, it's still not within the custodial interrogation.
Judge, I believe that the witness testified that Mr. King was in custody. At any time he was in custody. That triggers the obligation to have to grant before making any kind of statement.
Were the statements made from you asking questions?
No, ma'am. So he'd ask us a question, I'd let him know what was occurring, and then he would respond with, essentially, he said that was his house. So he asked what we're doing, I let him know the house was gonna be searched after search warrant was approved. He said there's nothing in there. He essentially several different times stated the house was his, but there was no direct question to him.
Is this part of the record? I don't think the court has moved on the admissibility. This is a statement by Mr. King. So my position is anything stated without being advised of its constitutional rights should not be admitted.
Regarding my question about whether or not these questions were asked by the officer, you have a response to that?
Yes, I would argue that the officer was saying the responses were not in response to police questioning, rather the defendants asking questions and making these statements. The Miranda warnings are also required that the warnings are required when police are asking questions that they know should elicit incriminating information. As the officers testifying to, actually, we're not even asking questions. So I would argue that Miranda warnings are relevant at this point.
Excuse me, Judge, may I voir dire the witness?
On
As to whether the state should be there. Just on that issue, as to whether on the admissibility of the state.
I'll allow it.
Yeah, officer, when you spoke to Mr. King, he was in custody. Would that be a fair statement?
Yes, sir.
Okay, and where was this conversation taking place?
So he was being searched. So whenever we take custody of someone else, we search just to make sure there's no further contraband. So it occurred outside the vehicle and then while he was in the backseat of the vehicle.
Okay, so when you first came in contact with Mr. King, he was standing outside the vehicle?
When I first came into contact with him, he was being escorted by two other officers up to our vehicle.
All right, so he was in the custody of the other officers, is that correct?
Correct.
Okay, was he handcuffed?
Yes.
And when you spoke to him, was that before or after he got into the vehicle?
Oh, it was before, sir.
Okay, so you approached Mr. King, and that's when you had your conversation with Mr. King, is that correct?
Correct, yeah. Mr. King was asking questions as to what was going on, essentially trying to find out why he was in custody, which is something people often do.
Okay, so at that time, Mr. King was not free to leave. Would that be a fair statement?
Correct.
Okay. And conversation began outside the car, is that correct?
Correct.
And then it continued after he was inside the car, is that correct?
He would continue to ask questions throughout the time at the scene. So whenever he asked a question, we do our best to give him an answer so he knew what was going on.
All right. And before, at no time before this, did you advise Mr. King of his Fifth Amendment rights, is that correct?
Correct. I also never asked him direct questions as to his involvement in the crime.
But you didn't advise him of his
Correct, I did not give him Miranda rights.
I don't have any further questions, and I'm, continue my objection.
I am going to, based off of the officer's testimony that he did not ask any questions of the defendant or interrogate him, I'm going to allow the statement.
Thank you, Your Honor. So when the defendant was, did the defendant make any statements regarding the residence?
He did.
And what were those statements?
So when he asked us what was going on, we let him know why he was in custody, why he was still there, because he hadn't been transported to jail yet. And we let him know that the house was gonna be searched looking for a pistol in there, at which time he replied, there's no pistol in the house. You know, he stated he lived there, stated, well, you know, whatever we're looking for, it's not in the house.
I have no further questions, Your Honor.
All right, good afternoon, officer. So you never did see Mr. King inside that house, is that correct?
Correct, sir, I did not.
Okay. And, when you first came in was that when you first came in contact with Mr. King? When you saw the other officers escorting him to the patrol car?
Correct, we thought initially he was inside the house, sir. And then when the other scouts stated that they,
Well, I'm not asking about what other officers said. The first time you saw Mr. King was when he was escorted to the,
That's correct,
patrol. Okay. And, you spoke with Mr. King, correct?
I did, sir.
Okay. Now, did you ever, outside of what Mr. King told you, did you ever, look at the title of the house, who owned the house?
No, I mean, I have no access to the title of the house.
What you indicated was just what Mr. King, told you, is that correct?
What's your question, sir?
Okay, when you indicated that that was his house, that was based on what information you got from him?
It's also what the witness's sister.
So I'm not asking about what anybody else said, I'm just, focusing on what Mr. King said.
So yes, he stated it was his house.
Okay. Now, you didn't find any, weapons on Mr. King's person, is that correct?
Correct.
You didn't find any ammunition on Mr. King's person, is that correct?
Correct.
One moment. Did somebody tell you there was a dead body in the house?
No, sir.
Okay, I don't have any further questions.
I have nothing further.
Okay, any defense witnesses?
No, we have no witnesses, Your Honor.
Mr. Kirk, whenever you are ready.
It's time the people have moved to bind over the defendants on counts of weapons, firearms, possession by a felon. Count 2, weapons, felony, firearm. Count 3, weapons, ammunition, possession by a felon. And count 4, weapons, felony, firearm. As we heard from Officer Durant, they received a call for a shot spotter, which is a technology that's what police use to indicate nearby gunshots. On arriving on the scene, it then turned into a potential felonious assault. They spoke with a complaining witness. Based on this, they then believed a house on the street might be occupied by a variegated gunman, so they called in additional units. Eventually, those additional units were able to detain the defendants and brought them back to the scene. Officers then conducted a welfare check of the house in which they searched for persons or injured persons based on the nature of the police room. Based on this search, they did not find any persons in the home, at which point they exited the home, obtained a search warrant to search for a firearm that was potentially used in this shooting. Officer Duran was part of executing that search warrant. He recovered 2 spent shell case, 9mm shell casings outside the north side of the home, 1 live 9mm round on the front porch, and 1 live 9mm round on the sofa. He also recovered a shotgun with live shotgun rounds in the basement bedroom of the building. He then also recovered medical records from within the home with the defendant Melvin King's name on them. Once outside of the home, defendant was asking officers questions about what is going on, why are they in custody. During this time, he then made statements that that was his home, that he lives there, that there's no pistol in the home, and that what the police were looking for, which would be the pistol, was not inside the home at the time. Based on this, the people believe they met the burden for probable cause for counts 1 through 4, not counts 5 and 6, and move to liability.
Yes, Your Honor, we would object to the prosecutor's motion. It's clear that Mr. King was never seen inside the home. There's nothing connecting him with the weapons that were allegedly found inside, nothing connecting him with the ammunition. Only thing, and I made my objection to the statements that obtained from Mr. King in violation of his rights. But let's say that Mr. King lived there. There's nothing to show that he knew what was in the house. And if the argument is that when he says that there's no gun in the house, I think the prosecutor is trying to take that to mean that he implicitly knew it was in the house. He may have honestly believed there wasn't a gun inside the house. But I don't think that shows a connection with the gun. So based on this evidence, that we would object to a bind over on all of the house. So basically, that's our argument. We object to a bind.
Your Honor, based on the defendant's statements that this is his home, that he resides at the home, I believe it is not for constructive possession of the weapons and ammunition that were located in the home. That what the police were not looking for was, or what the police were looking for was not inside the home, was in regard to the pistol that they were looking for, which was in fact never recovered in the home. So based on this, we believe the defendant did have knowledge of what was in the home, that it was his residence, that he would have constructive possession over the ammunition and weapons recovered in the home. But again, we will find over this.
This case is one circumstantial for sure. I do believe that further proof of probable cause, not only circumstantial, but also people are relying on constructive possession here, which requires knowledge. I do believe that the defendant had knowledge based on the fact that he admitted that it was his home and that the gun was found in the bedroom, as well as ammunition on the couch. And although there was no observation of the defendant being near those items, it goes back to circumstantially and the probable cause standard, meaning those elements. And also, there's a issue, Attorney Washington, I noticed, Miranda issue. I don't believe that the defendant was being interrogated based on testimony. Of course, that could be raised in the Third Circuit. So for count one, for weapons, firearms, possession by a felon, there was a shotgun that I do believe the defendant had knowledge of the ability to control at some point the house that he admitted his, as well as the accompanying felony firearm charge, as well as count three, possession by a felon ammunition, along with exhibit one, satisfied that count as there were live rounds in the shotgun, as well as live rounds on the couch. And count four is the accompanying felony firearm. And count five is absolutely circumstantial. But it can be inferred that the defendant discharged in or at that building based off of the spent shell casing, the shotgun in the house, live rounds in the shotgun, and defendant's admission that it was his home, that there was no one else in the home when the police arrived to the call from the shots fired. So that count six will be bound over as well as the accompanying felony firearm. So, Mr. King, you are in custody. So your arraignment on the information date will be 1 week from today. So it'll be June 14th, 9:05 a.m. Frank Murphy Hall of Justice.
Excuse me, Your Honor, we heard on the issue of bond.
Yes.
Now, what I'm seeing is that his current bond is 50,000 cash. We would ask if the court would consider a bond reduction. I'm not aware of any flights. The way we see it's not the strongest case. We would respectfully ask that the court.
Anything for the people?
Would object to reduction of bonds or insist on at least on no contact with this case.
So there is a,
He would be amenable to a check.
yes, okay. Complaining witness on this case?
There is, Your Honor.
All right, so I've heard people's objection. What I will do, I will adjust the bond to a 50,000 personal, but it will be house arrest. You have no contact with the complaining witness. And I need to know where you're residing, Mr. King. Where's that?
I stay with my mother. That's why I can't really
I
say
just need
that.
to know the address where you
All
reside.
right. Well,
Okay, I received your address and where you be staying, so I will change it to 50,000 personal. No contact with the complaining witness, you are a house arrest. With the tenant.
all right.
Have a good day.
Thank you.
All right, take care of yourself.